At the nation's capital, congressional Democrats have released a counteroffer to fund the government and avoid a possible shutdown next month. But Republicans are pushing ahead with their own plan, passing a key House vote. Meanwhile, in a second day of congressional questioning, FBI Director Kash Patel clashed with House lawmakers about his calls to release the Epstein files before he became head of the agency. They accused him of orchestrating a cover-up to protect President Trump. CBS News congressional reporter Torian Small joins us now from our D.C. bureau with more on all of this. Good morning, Torian. Mr. Patel got into several heated exchanges yesterday, and specifically about the Epstein files. Let's just quickly play a quick clip of that for our viewers.
It sounds like if you don't know the number, it could at least be 1,000 times.
It's not. It's not.
Is it at least 500 times?
No.
Is it at least 100 times?
No.
Then what's the number?
I don't know the number, but it's not that.
Do you think it might be your job to know the number?
My job is to provide for the safety.
It by nearly 2 months. And when documents were finally released, they were drenched in black ink, heavy redactions, missing names, entire sections unreadable. That's when eyebrows started raising across Capitol Hill. Epstein wasn't just any criminal. He was connected to billionaires, politicians, royalty, and powerful elites. His little black book has fueled speculation for years. And yes, Donald Trump's past association with Epstein, photos, public comments, social appearances, keeps his name in the orbit of the story, even though there's no proven evidence tying him to Epstein's crimes. So when documents are delayed, then redacted, then defended with vague references to sealed court orders, lawmakers want proof. On February 17th, the House Oversight Committee sent a formal demand to Patel. Not a casual request, a demand. Show us the court orders, explain the delay, clarify the FBI's role. Because here's the reality, sealed court orders are legitimate. Courts can block releases to protect ongoing investigations or classified information, but those orders must exist. They must be specific. They must be documented. If Patel cannot produce them, or if they don't justify a 2-month delay, the situation escalates quickly. Misleading Congress is not a public relations problem. It's potentially criminal. Congress can subpoena documents. They can compel testimony under oath. They can hold hearings. They can pursue contempt referrals. And if it turns out Patel misrepresented the facts, his credibility collapses. For someone who built his public persona as a warrior for transparency against the so-called deep state, that's politically devastating. Now add a second front to this battle. While Congress investigates the Epstein-Dabar file delay, Patel is facing a federal civil rights lawsuit. After 16 years in the FBI's Los Angeles field office, a veteran intelligence specialist, David Maltinsky, was weeks away from promotion special agent. Then, he was called into a meeting and terminated. The reason cited, an inappropriate political display. The display in question, a progress pride flag. According to the lawsuit, the flag had previously flown outside the FBI's Los Angeles office in 2021 and had been presented internally. Maltinsky says he displayed it in his workspace, shortly after he was escorted out. The termination letter carried Kash Patel's signature. That detail changes everything. This wasn't a mid-level HR call. The FBI director signed off Maltinsky's. Legal team argues the firing violated the First Amendment and federal employment protections. They claim he was punished for expressing LGBTQ+ identity, protected speech. They're asking for reinstatement, back pay, damages, and a formal ruling declaring the firing unconstitutional. And here's the key issue. Patel is named personally. In the lawsuit, if a court finds constitutional violations, he could face personal liability for damages and legal fees. Civil rights cases move fast. Discovery begins. Emails get requested. Internal communications surface. Depositions happen under oath. If evidence shows the termination lacked legitimate performance grounds and was directly tied to the pride flag display, the defense becomes extremely difficult. And politically, it feeds into broader narratives about the administration's stance on LGBTQ+ visibility in federal institutions. Now look at the bigger picture. On one side, Congress investigating whether he misled lawmakers about sealed court orders and delayed document releases in a politically sensitive case. On the other side, a federal court examining whether he violated constitutional rights in an employment decision. Both demand documentation, Both demand sworn explanations. Both carry real consequences. This isn't cable news debate territory anymore. This is legal exposure. And you can already see a shift in tone. Patel has grown quieter publicly, fewer appearances, fewer bold declarations, because it's one thing to spar on television. It's another thing entirely to sit under oath. The Epstein files controversy isn't just about redactions. It's about whether federal law enforcement was used to shield powerful individuals. If Congress concludes that documents were intentionally stalled to protect political interests, it becomes a serious abuse of power allegation. Meanwhile, the pride flag lawsuit isn't culture war rhetoric. It's constitutional law. If the court rules the firing unlawful, it sends a clear signal that executive authority has limits. And when judges and lawmakers start seeing patterns, delayed transparency here, questionable termination there, it builds a narrative of someone acting as if rules are flexible. Courts don't like that. Congress doesn't like that. And historically, officials who appear to operate above oversight often face the harshest scrutiny. What happens? Next, for the Epstein files, Patel must produce proof of sealed court orders. He must explain the 2-month delay. He may face subpoenas or testimony under oath. For the lawsuit, discovery could reveal internal communications. Depositions will force sworn answers. A settlement would carry political consequences. A loss would carry financial and reputational damage. There is no easy exit strategy. Delay won't solve it. Silence won't solve it. Deflection won't solve it, because investigations don't expire. Lawsuits don't evaporate. They stretch on for months, sometimes years. And every day they remain active. The scrutiny intensifies. For the first time in his tenure, Kash Patel is confronting simultaneous legal and congressional pressure. Courts are not moved by political loyalty. Congress is not swayed by television appearances. If rules were followed, documentation will prove it. If they weren't, consequences follow. And that's the reality now closing in, because in Washington, power can shield you from criticism, but it cannot shield you from subpoenas, and it definitely cannot shield you from a federal judge.